Gentlemen, welcome. And the first case to come in front of the court is Schutte versus Strittmatter. And am I pronouncing that right? Schutte?
I believe so, yes.
Okay. All right. All right. Anyway, so each side will have 15 minutes to present their arguments. And I'm sure you both know that we are streaming live and we record this. So yours is a civil case, so we don't necessarily have to worry so much about victims, and I don't think there's any children involved in this, but ordinarily we wouldn't want to mention a victim's name or a child's name. And Mr. Flowers, you have the ability to save up to 5 minutes.
I'd like to save three, Your Honor.
Save 3? Okay. All right, and then we'll be ready to go. Thank you.
Thank you. Your Honors, may it please the court, my name is Paul Flowers. I represent the plaintiff appellant in this case, Robert Schutte. I'm not going to go through all the details, which both parties have laid out in their briefs, but this is a dispute between neighboring property owners. It's gone on for several years. We were before this court a few years ago arguing an appeal. And now we're here with what's left, which is a counterclaim judgment that was entered against my client for in excess of $215,000. And that's what we'll be talking about today. Let me just note at the outset that the counterclaim has 2 counts. The first is for tortious interference with the contract. And on that one, the jury awarded economic damages of $9,000 and some change, and then non-economic damages of $150,000. The second count was for criminal damaging, which was based upon some allegedly destroyed snow markers and so forth. And the jury's award on that was just $166.18. So as you probably gathered, we'll be talking primarily this morning about the tortious interference claim. I'll start with that. And our first assignment of error, which was that a directed verdict or judgment notwithstanding the verdict should have been granted on the tortious interference claim. Our standard of review here is de novo, as I'm sure the court is aware. In preparing for this, I thought the timing was really interesting because we've been following the Gibson brothers versus Oberlin College case in our office very closely. And I know this was argued in this court in November, and you're going to hear a lot of the same arguments as far as the free speech and protection of opinions go. But it'll be interesting to see how both that case and this case shake out. In this case, the parties are in agreement on a number of important points. First, we all agree that a tort claim cannot be based upon protective speech, even in part. The case we cite for that is Martinez versus WTG Inc., the 6th district case from 2008. And also we agree that Ohio has its own protection for opinions in Article 1, Section 11 of the Ohio Constitution that is independent of the U.S. First Amendment protections. These protections of opinions are extremely broad. It doesn't matter how derogatory or offensive the opinions may be, they're still protected. And we've cited quite a few cases recognizing that. And one out of this court is Plow versus Schneider. It's a 9th district case that Judge Carr authored in 1992, which makes those points very directly. So in Ohio, the debate really comes down to, as it does in this case, whether we're talking about opinions or fact, because once they're opinions, it's game over. They're fully protected. And as was discussed at length in the Oberlin College case, the factors to be considered, and it's a multi-factor totality of the circumstances test, the factors to be considered from Scott versus News Herald, the Supreme Court 1986 case. They wrote, consideration of the totality of circumstances to ascertain whether a statement is opinion or fact involves 4 factors, at least 4 factors. First is the specific language used. Second is whether the statement is verifiable. Third is the general context of the statement. And fourth is the broader context in which the statements appear. Based on that, all we have to look at here is a brief scenario, one-time scenario that occurred at the property at issue. It was an inspection of a septic tank that was being conducted on behalf of potential purchasers. The actual purchaser, Mr. Wu, was not there. His fiance was there. along with a real estate agent, the inspector. And the comments that my client made as he's walking back and forth on his lawn, holding a rake, begin with buyer beware. That's a recommendation. Nothing factual about that. He said the septic system is going to fail. That's a prediction. It may still be true. There's no time limit on that. But it's not verifiable one way or the other whether or not the septic tank is going to fail. He said the driveway is going to be replaced. Again, that's a prediction. And honestly, all driveways at some point need replaced. I mean, I'd have to say this is a true statement. I mean, even a gravel driveway, you have to fill it with gravel every now and then. He said that anybody buying this property, or words to this effect, would be involved in litigation and inheriting a nightmare. And both parts of that are true, because at the time, there was still the dispute over the driveway involving both property owners, and the purchaser was going to inherit that. There's no doubt about that. And Mr. Fitzgibbons itself described it as a nightmare. I mean, that's how he got this $150,000 award driven up, was just talking about how upset he was over this whole thing. So what Mr. Schutte is saying here is not just unverifiable, it's actually accurate. And then there was the comments about he didn't believe everything was being disclosed. Again, not verifiable, and also true, because at that point in time, and Mr. Schutte didn't know this, at that point in time, all Mr. Fitzgibbons had done was provide the case number for the lawsuit and some very cryptic explanation that didn't make it sound like a nightmare at all. And that was all he provided. And that's important because Mr. Wu hears all this secondhand, apparently, either from the agent or his fiance. And he doesn't accept any of this as fact. That's not his testimony. His testimony is that he needed to look into it further, which he does. He makes rather thorough a due diligence investigation, and at that point decides to exercise his right to back out, which Mr. Fitzgibbons accepts.
Counsel, let me just interrupt you. When you were going over these statements that were made, two things come to mind. One is just what you started with, the totality of the circumstances. And, even if you're correct that these, septic tank is going to fail, that kind of thing, and driveway will need to be replaced, in and of themselves, that may not be something that would be defamatory. But again, like you started your argument with, you have to put it in the context of this ongoing feud between the two of them. Well, three of them actually, but the two here especially. And, what he was trying to accomplish with this, and, what had happened in the past, all those things. I guess I'm a little concerned when you're just listing out the statement in a vacuum, I guess is my point. And then I have a second one too. Okay. And that is, didn't he also say something about the septic tank had failed in the past and leaked onto his property?
Well, let me just address the first part first. Absolutely. Okay. Scott says totality of the circumstances. And I think we do have to look at that broad picture. And I'm going to get to that in a second. Just as far as the septic tank had failed in the past, that's not my understanding. And I'm not sure the veracity of that. It cleared this inspection. So I'm not sure that would matter, that Mr. Wu would take that seriously or it have any impact on him if that was what was said. But the statement that it is going to fail, who knows? I mean, if they're not maintained, they're all going to fail at some point. And then to go back to the first part of your question, the totality of the circumstances, yeah, you have to look at this. And sure, there's this feud going on between Mr. Schutte and Mr. Fitzgibbons, but this isn't directed at Mr. Fitzgibbons. These comments are directed at Mr. Wu, or Mr. Wu's fiance, I guess, is how this is going. And you have to get the mental picture of what has been described during the jury trial. And that's Mr. Schutte holding a rake, walking back and forth, not claiming to be any sort of expert or specialist or somebody in the know, but just kind of making these comments. So the real estate agent, I think it's Ms. Hudson, she says, her testimony is she called him a weirdo to the inspector and they high-fived each other. And there's testimony here about how it was creepy and unnerving and odd, and all that. Nobody says like, hey, you know, we took this seriously. When he said the septic tank was going to fail, we thought it was going to fail tomorrow. Nobody says that, and nobody gives it this kind of aura of credibility or truth or anything like that. It's just a neighbor walking back who may or may not know what he's talking about, saying these things. And then it's kind of like a proof is in the pudding thing. I mean, Mr. Wu doesn't call up the next day and say, I want out, you know, the septic tank's going to fail, the driveway needs replaced. I mean, he just does his due diligence and he finds out what the real facts are and then exercises his right, you know, which Mr. Fitzgibbons accepts, to back out, you know, of the contract. So if you look at the whole big picture, there's never any sort of instance where anybody is taking any of this as established, verifiable fact and acting on it. It is the whole picture that matters, and I do encourage the court to look at it that way. And just as I wrap up on this, keep in mind that we all agree, first of all, that this is a matter of law for the court to determine whether or not it's opinion or fact. And second of all, we all agree that a tort claim can't be based even in part upon protected speech. And this jury was urged to base their decision on what we have here. Not just the tortious interference claim, but also the punitive damage award. You know, that the whole gambit of it should flow into these awards. And that's surely what they did. I mean, you can't just pick out one of these and say, you know, okay, that's opinion, we'll take that out and we'll affirm, because it played a role into this, and it could not have. It should have been off limits throughout the whole trial. Then just turning to the merits of the tortious interference claim itself, we have a well-defined tort of tortious interference of contract in Ohio that was defined in the Kenty, K-E-N-T-Y, Ohio Supreme Court decision in 1995. And the elements are, 1, the existence of a contract; 2, the wrongdoer's knowledge of the contract; 3, the wrongdoer's intentional procurement of the contract's breach; 4, lack of justification; and 5, resulting damages. Now, 2 jump out at me here that haven't been satisfied as a matter of law in this case. And the first is knowledge of the contract. There's no proof of that. All Mr. Schutte could have done was surmise that Ms. Wu's fiance, or Ms. Wu herself, who was not Ms. Wu at the time, that she was purchasing the property. You know, he had no knowledge of an actual agreement. He had no knowledge of any sort of a commitment. There's no proof of that. And this court in Akron Group Services versus Patron Plastics, it's a 9th District case from 2005, addressed that very point and said, you know, potential contract is not enough. A prospective buyer is not enough. You know, we want, you know, knowledge of a contract, because this is an intentional tort. I mean, Mr. Schutte is being accused of intentionally securing a breach of this contract. So kind of some vague, iffy thing isn't enough. You have to show that he knew about it in order to get to the next step, which was this was his objective.
Mr. Flowers, I want to interrupt you because you are at your 3 minutes. If you want to continue, that's fine. But
I'll just say real briefly, we also need a breach of the contract, which everyone agrees we don't have here. The defendants have some Sixth Circuit authority that doesn't cite Ohio law. Say stick with the Kenty case, stick with the Akron Group Services case, and reverse the trial court's final judgment. Thank you.
Thank you. Mr. O'Malley, you have 15 minutes. You have to unmute yourself, please. Now let's try it.
Thank you, Your Honor.
Thank you.
May it please the court. Brian O'Malley on behalf of Brian Fitzgibbon, who's the appellee in this case. And Your Honor, I find it very ironic that Robert Schutte is back before the court again. As you certainly recall, that he insisted upon, and the court properly found, that he had a constitutional right to a jury trial. And now he's back again to complain about the jury trial that he insisted that he was entitled to have. And Mr. Flowers is back again as well with another constitutional claim. Your Honor, we don't dispute the constitutional provisions that Mr. Flowers is referring to. However, this was not a defamation case. This was not a constitutional claim. And certainly the Constitution doesn't contemplate unlimited false and malicious statements by Mr. Schutte with respect to his neighbor's real estate contract. Interestingly, at June 2nd, 2015, that was the date that this septic inspection was scheduled. This came after this action was refiled. Mr. Fitzgibbons, unfortunately, marks his days in this case as the years go by, having first been sued by Mr. Schutte in 2014 and being sued a second time by Mr. Schutte in 2015. As the court was made reference to the previous bench trial and appeal, that was in 2016. But it's a very, very extensive record. There's several volumes. There's a lot of video. I'm sure, and I'm sure that your staff has had many hours of reviewing. Unfortunately, all of the different issues that were presented to the jury. Your Honors, let me stop for a second. And let me first say that the appellant has presented 4 assignments of error, 2 of which depend upon a demonstration of abuse of discretion by the trial court. The appellant has made very little effort to demonstrate an abuse of discretion by the trial court in support of the 2nd and 3rd assignments of error. And there's no hint of an abuse of discretion by the trial court. The trial judge literally conceded in every respect to enable Mr. Schutte to be heard in this jury trial. The trial judge followed the court's instruction to give Mr. Schutte the jury trial that he insisted upon having. In fact, if anyone was limited during the jury trial, it was the theories and the presentation that Mr. Fitzgibbons wanted to present. Most importantly, on September 20th, 2016, the trial court dismissed Mr. Schutte's claims against the City of Greene regarding the plat and the vacation of the right-of-way. Within the week, Mr. Schutte exercised self-help to excavate the gravel. That was the gravel drive. Coincidentally, this was occurring at not long after a second real estate contract was entered into. Mr. Flowers makes reference to it in his brief. It was a new purchase agreement dated August 15, 2016. I'm sorry, Your Honors, I'm a little confused here in terms of the recitation, but to put this case into the context that is unfolded, Mr. Fitzgibbons had a contract to sell his house to Chris Wu, and Mr. Schutte maliciously, intentionally, and without justification interfered with it.
Well, let me stop you. Let me stop you right here, Mr. O'Malley. One of the things that the appellant is arguing is that there was no evidence presented that that Mr. Schutte actually had a knowledge of the contract.
Your Honor, I believe that was certainly within the province of the jury to conclude from the circumstantial evidence that was presented. Mr. Schutte started, Jody Workman Hodson, the realtor, the buyer's realtor, believed that he was taking pictures during the septic sewer inspection, told him to stop it. He retreated to further back in the yard, and she went back to talk to him. On at least 4 or 5 times, he insisted that Keller Williams, which was the seller's realtor, had failed to fully disclose all of the defects and issues. I think that she insisted that 5 times he repeated that there was a non-disclosure by, and I have to correct Mr. Flowers. He's completely mistaken. There was full and complete disclosure. In fact, Jody Hodson explained that she would not have scheduled the septic sewer inspection until after she had received the responses to the demand for a more detailed explanation of the boundary dispute. The initial real estate disclosure statement made reference to it, and the buyers asked for more details, and I believe it's Exhibit 3. It's fully and completely disclosing each and every lawsuit and the status, the actions by the city council. The city council passed an ordinance in 2014 to vacate the right-of-way and recorded the vacation plat in February of 2015 before this lawsuit was refiled.
Counsel, let me go back to my question, if you don't care. What evidence was presented at trial to demonstrate that Mr. Schutte knew there was an actual contract between Mr. Fitzgibbons and Mr. Wu at the time that he was making these comments?
Your Honor, I think that the jury inferred that from the circumstances that were presented there at the scene of the septic sewer inspection. You
think that the jury could infer from the fact that they were just doing an inspection that there definitely was a contract, and he knew that?
Yes, Your Honor, and further based upon the conversation that ensued between him and Jennifer, her name was Sensky, since Jennifer Wu was also party to the conversation. She went back and joined the conversation with Mr. Schutte, and that was certainly, it was, Your Honor, it was taken for, I wouldn't say taken for granted, but it was certainly within the totality of the circumstances and the facts that were presented to the jury. There was a for sale sign posted.
Well, let me get back to the realtors. Did either realtor testify that they indicated to Mr. Schutte that there was a pending contract on the property?
I don't recall that from the records, Your Honor. No.
Okay. Thank you.
Your Honor, I think that the appellant has taken what I would call a scattergun approach to the first assignment of error. And interestingly, one of the items that he was trying to get to before he ran out of time was this clever argument that if the underlying contract was released, then and the actual breach in the formal sense didn't occur, then therefore we failed to meet that element. Your Honor, the Ohio jurisprudence and the Ohio jury instructions focus on the procurement of breach. If you follow the appellant's logic in this regard, Mr. Fitzgibbons' only recourse is to try and forcibly compel Chris Wu and his fiancee to proceed with and complete the real estate transaction after what they experienced. It's a far different thing to see disclosures on a real estate form, and another thing entirely to come face to face with your new neighbor, who is creepy was the word that Jennifer used. Weirdo was the word that that was used by the realtor. But I don't want the court to accept the appellant's assessment that Mr. Schutte was punished for his exercise of free speech.
Counsel, let me stop you right there again. Excuse me. It seems to me like the testimony from Mr. Wu and his fiance went more to the fact that they really don't want to live by Mr. Schutte. He was a weirdo and creepy, and he freaked them out. Is that in being a weirdo and a creep and freaking somebody out? Is that enough to intentionally interfere with a breach of a contract, tortious interference of a contract?
Your Honor, I think that there is a fair characterization that you've made of Chris Wu and Jennifer Wu. However, I don't think that any of these items is taken in isolation or taken in a vacuum. And the testimony that was presented to the jury is reviewing all of the witnesses and their credibility, and there was extensive examination of the witnesses as to, I think Chris Wu said the greater catalyst was Robert Schutte's behavior, but not just his behavior, Your Honor, the false and malicious statements of fact, which the appellant has attempted to characterize as mere opinion. He insisted that there was a failure to disclose, which was an absolute falsehood. He insisted that the driveway would have to be replaced, which was an absolute falsehood. The vacation plan had been recorded 3 months prior. The easements were in the books. There was no reason that the driveway would be replaced. It was conceded that there was some truth to the suggestion that they would be dragged into this lawsuit as was threatened by Mr. Schutte, and that he would make their lives also a nightmare. Those opinions, if you will, perhaps facts, were conceded by the Fitzgibbon in the course of the trial. But the other things were false. He falsely claimed that the septic sewer had failed, had drained onto the other property. And the Benjamin Skelly, the septic inspector, he brought all of his records. There was no history of any failure. It wasn't a prediction about whether it would fail. He said that it was failing. There were false statements of fact that are not protected by the Constitution. This was not a constitutional tort claim, a defamation claim that was brought. Now, it's not as if he's standing on a street corner or in front of a business declaring buyer beware. It was focused not on Chris Wu, but on his neighbor that he had an axe to grind with. He did not appreciate the fact that his neighbors didn't tolerate his insistence that this right-of-way be constructed into a street. He didn't, and you saw the testimony from Paul Pickett, the city engineer, the years of time and effort by the city to try and resolve this issue with this quote-unquote paper street. And Mr. Schutte's insistence that he was going to, you have to keep in mind also, Your Honors, this gravel driveway serviced Fitzgibbon's house and Strittmatter's house. It never connected to Schutte's property. Schutte insisted upon what Pickett agreed was a road to nowhere, and he refused to use his own driveway. He had his own driveway.
Counsel, you only have about a minute left, and I'd like to ask you another question in regard to the actual tortious interference. Is it your position there definitely was a breach here, and a breach is necessary for one of the elements of tortious interference?
It's not a breach, Your Honor, but a procurement of a breach. It is.
Well, if there's no breach, how can you have a procurement of a breach?
It's focused on what Mr. Schutte did to interfere with and to procure, obtain, prompt, secure, cause Chris Wu not to perform, not to proceed with his contract. And that's what happened here. Your Honor, I was going to say,
you're out of time now if you want to just finish up real quickly.
Your Honor, we would ask the court to affirm the wise judgment of the jury. These matters are wholly and entirely within the province of the jury to determine. And we would ask the court to affirm the ruling.
Thank you. Mr. Flowers, you have another 3 minutes.
Thank you, Your Honor. Let me just say, first of all, that my client and I, we do appreciate that we got a jury trial and the second time back. But everybody agrees here that whether or not what Mr. Schutte said was protected opinion or was fact, that's an issue for the court. That's not a jury issue, and they were never asked to resolve that. That's from the Scott versus News Herald Supreme Court case. And just to go into those comments, I know Judge Carr asked that question about the septic tank, that it had failed, and that's in the defendant's brief. But the testimony from Jody Workman, who was the real estate agent, this is in volume 1, page 69 of the transcript. She says, and I'm quoting, "And then he said the septic was going to fail." So that's the future tense. That's not the past tense. Then that's unverifiable. It may fail, it may not fail, who knows? My client wasn't claiming to be an expert, and this is not a verifiable fact, and it doesn't appear to make any difference to Mr. Wu, because it's not why he backed out of this. So that is what Ms. Workman described the comment as in her testimony. And just as far as the disclosures, maybe Mr. Fitzgibbons disclosed just enough to satisfy his requirements under law by providing a case number and a brief description, but he didn't describe the nightmare. He didn't describe what he later described to the jury, how his life was thrown around, all that. He didn't tell Mr. Wu any about that. And if there was this full disclosure that I'm misleading the court about, why did Mr. Wu do this investigation and come up with this new information that was important to him? Obviously, if he's finding more stuff, there's an argument to be made that it wasn't full disclosure. And if there's an argument to be made over the veracity of these comments, it's opinion, it's not fact. Just going to the merits of the claim, there's no proof here of knowledge of contract. And again, I know I'm repeating myself, but in Akron Group Services, this court focused right in on that issue and said, the fact you may be aware that there might be a contract, that's not enough. This is an intentional tort that carries with it the specter of punitive damages. So we expect more. And remember, in this contract did provide, like a lot of them do, that Mr. Wu had the right to back out upon further investigation. If you look at Ms. Workman's testimony, she explains all this, that it wasn't like, Mr. Fitzgibbon could have forced him to go through with the contract, because Mr. Wu had this right. So this isn't even really what you would call a binding contract at that moment. It would become binding after a passage of time for the inspections. Going then to our remaining assignments of error. Oh, wait, and just going back to the full picture, all of this testimony that was creepy, it was weird. We had people high-fiving each other. That just shows that nobody was taking this as fact. That just shows that this was all commentary, remarks, opinions that no one was taking seriously. It just doesn't fall within the gambit of fact upon which you can base an intentional tort and get punitive damages.
Counsel, I have to inform you, you're out of time.
Yes,
Thank you very much.
On all those terms, we'd ask you to reverse. Thank you.
Thank you. Thank you both for your professional arguments and your good arguments, and we will take the matter under advisement, and we will issue a written opinion that will be sent to both sides, as well as we release it on our website for the Supreme Court and electronically. So if you're really anxious, you can look there. All right. Thank you very much. And I hope you